Our next case for today is 2020-10093, Franciscan Alliance et al. Versus Norris Cochran, Acting Secretary et al. Versus American Civil Liberties Union of Texas River City Gender Alliance interveners. Mr. Davis, you may proceed.
Thank you, Your Honor, and may it please the court. In at least 20 contraceptive mandate cases in jurisdictions around the country, courts have already considered the proper remedy for when HHS violates RFRA by trying to force religious people to pay for objectionable medical services. In those cases, the answer has been uniform. The courts have entered an injunction. Moreover, in every single one of the 20 cases collected in our brief, the injunctions themselves have been uniform. They've been plaintiff-specific injunctions, and they've stopped HHS from applying not only its own regulations, but also the underlying statute to impose the challenge requirement. That's exactly the relief that plaintiffs are seeking here with respect to HHS's radical attempt to require them not only to pay for, but also to perform gender transitions and abortions contrary to their religious beliefs and their medical judgment.
Counsel, can I back up and ask you maybe just a very elementary question that maybe the answer should be obvious, but it's lost on me. Are we still talking about the 2016 rule, the rule that was subsequent to that I think existed at the time the appeal was taken? And then, of course, we got your 28J with the proposition of yet another change in the rule. Can you tell us which one we're talking about here? Maybe we're talking about all three.
Your Honor, I think that's a very helpful question. And what we're talking about is the government's action trying to apply Section 1557 to require these plaintiffs to perform these procedures or else risk the massive financial penalties that can come under Section 1557. So the relief we're seeking is aimed at that burden, and that's consistent with RFRA. So the object of a RFRA case is about the burden on religion. And so the proper remedy—
about all three, basically, at this point.
Your Honor, that's right, Your Honor. We're talking about action under Section 1557, and that puts us—
Counsel, but you're also talking about still the 2016 regulation, aren't you? Because the Walker-Whitman case has said that the sex stereotyping includes the proposition for which Judge O'Connor had lined through, but they said now that proposition includes the point, and so it kind of moots out the relief that Judge O'Connor gave, doesn't it?
I think that's right, Your Honor. As we sit here today, we've got two other district courts: the Whitman-Walker case, the Whitman-Walker Court in D.C., the Walker Court in New York, that have actually brought back provisions of the 2016 rule that impose upon plaintiffs the very substantial burden that Judge O'Connor held to violate RFRA, correctly held to violate RFRA.
So we don't have to decide, do we, whether we're dealing with the 2020 rule or even 1557 if it's still dealing with the 2016 rule, do we?
I think it's true, Your Honor, that the 2016 rule still imposes the burden, and we still need additional relief. And I think it's exactly right that to the extent that Judge O'Connor's opinion was premised on the idea that vacatur is enough, I mean, subsequent events have shown that vacatur is not enough.
And why couldn't you have just gone back to Judge O'Connor, because he specifically said, why is an appeal the right vehicle, given that he specifically said if you need further relief or something changes, come back to me, or whatever the language specifically was?
Well, Your Honor, I think his come back to me language was more about the 2016 rule, whereas, again, what we're seeking here is the same relief that the plaintiffs got in the contraceptive mandate cases, the same relief that the plaintiffs got in the Sisters of Mercy case just a couple of weeks ago, which is relief that's aimed at the burden. So
but he doesn't have to give that relief, does he? I mean, are you saying that it's abuse of discretion not to give that relief?
So, Your Honor, I think the Opulent Life Church opinion is really helpful here, where Judge Elrod explained for this court that it was abuse of discretion in that case for the district court to refuse to enter an injunction on irreparable harm grounds because the court said that a RFRA violation or a RLUIPA violation is itself irreparable harm. So I think, and that reasoning that's in Judge McConnell's opinion in the Ocentro case, that's in Judge Sykes's opinion in the Corte versus Sebelius case here. And I think it's important in the Corte versus Sebelius case for the Seventh Circuit, excuse me. I think it's important to note that we're not just talking about the 20 contraceptive mandate injunctions, which are precisely analogous to this case. Plaintiffs are actually unaware of any other case in any jurisdiction in the whole history of RFRA in which a court has found a prospective RFRA violation, but then nonetheless refused to enter an injunction. And neither HHS nor ACLU here has been able to muster a single counterexample of their own.
Davis, a quick question. So your brief cites all these RFRA cases that resulted in injunctions, but did any of those cases also involve APA claims?
No, they didn't, Your Honor, but I think there's a lot of cases there, but I'm not off the top of my head aware of any that did. But I think that gets—
I guess my question is, in how many cases has the district court done what you're seeking here, which is vacate a rule under the APA and issue a permanent injunction against a RFRA violation?
So I think it's helpful for the court to look at the Department of Commerce case, which is a post-Monsanto decision. And the Department of Commerce case, it's not a RFRA case, but there the court says it distinguishes the Monsanto case that Judge O'Connor relied on here. And it does so precisely on the ground that vacatur alone wouldn't actually stop the party to be enjoined, which there was a federal agency, from reimposing the challenged action. And this case is squarely in Department of Commerce land. We're talking about the vacatur alone doesn't stop HHS from imposing the burden on plaintiffs' religious beliefs. It can impose that burden under Section 1557 itself, which doesn't require—
When you were before Judge O'Connor, did you ask him for anything resembling the specific injunction that you're seeking now?
Yes, Your Honor. We asked him in RE 118 in the injunction that we submitted to the court and asked him to enter for us. It sought this exact relief.
That was your proposed order, correct? But was it in your briefs? Was it in your argument before him, other than in that proposed order?
So, Your Honor, it was in the proposed order, and then our briefs made the case that we were entitled to injunctive relief and applied the 4 injunctive relief factors and went through them all and showed that we met them. And we met them because, again, under Opulent Life Church, once a plaintiff shows a RFRA violation on the merits, the other injunctive relief factors follow from that, inevitably and as a matter of law. And as a matter of law is the language that the court used in Opulent Life Church when talking about the holding that a RFRA violation is itself irreparable harm. And I think it's striking that neither HHS nor ACLU in their briefs below took any issue with that part of the injunction that the plaintiff sought. Instead, they took issue only with this question about whether it was appropriate for an injunction to be nationwide or not.
Let me ask you this. Would your proposed injunction, would it prohibit HHS from attempting to implement a new rule based on a different record?
No, Your Honor. I think that's a great question. This is a straw man argument that we've heard again and again from ACLU and HHS so far in this appeal. The plaintiffs are not trying to strike down future regulations. We're not trying to stop HHS from passing any regulation that it wants. What HHS can't do under the injunction that we're seeking here is apply Section 1557 to these plaintiffs, the plaintiffs that are before the court, in order to require them to perform or ensure gender transitions or abortions. And that's appropriate.
At what point in the rulemaking process would you attempt to bring HHS back before the district court?
You mean if we got the injunction that we're seeking here, Your Honor?
Well, it's kind of a tag on to my earlier question, in which you were kind of in the process of answering about whether the proposed permanent injunction would bar HHS from implementing or trying to implement a new rule based on a different record. And I guess my follow-up was, well, at what point in that rulemaking process would you attempt to bring HHS back before the district court?
So I think the answer to that question, Your Honor, is that our injunction would stop them from applying this new rule or Section 1557 itself or the 2016 rule, whatever the case may be, to impose sanctions on these plaintiffs. So it wouldn't be about trying to stop a rulemaking from going forward. It would be an injunction that says, hey, HHS, whatever your rule is, you can't apply it to these plaintiffs to perform these actions. And again, that puts us right on point with the contraceptive mandate injunctions, which had exactly the same structure. They didn't just enjoin the precise regulations that had existed at the time the Obama administration originally enacted the contraceptive mandate. And in fact, those cases actually had a really similar posture to this case in a lot of ways. So there, just like here, the contraceptive mandate originally appeared in Obama era regulations. But then, just like here, when the mandate was found to violate RFRA, the Trump administration came in and tried to fix it. And then just like—
Why shouldn't we just, if we were to agree with you, assuming arguendo, not trying to foreshadow, why wouldn't we just remand for the district court to consider in light of the new circumstances of the other injunctions, if anything needs to be done, rather than dictating an injunction at this point, especially when it's not clear whether the district court specifically rejected your statutory part of the injunction earlier on the statutory basis, or whether it was just because it overlooked it or something like that. We don't know. So why would we not just remand?
Your Honor, I think at minimum, the appropriate relief here would be a remand for precisely the reasons that you just discussed. But a remand is simply unnecessary here, and the court could look at the Corte versus Sebelius case, which there the Seventh Circuit said that once it had found that the legal reason that the district court declined to enter an injunction was wrong, then there was no need to remand for application of the injunction factors, because the injunction factors flow once you found a RFRA violation or a RLUIPA violation on the merits. And again, that's Opulent Life Church from this circuit. And they're actually strong.
Concerned, though, that we would be setting up one of those conflicts that we've been reading about in the past few years between different courts and different jurisdictions on these dueling injunctions. Should we be concerned about that in comity and those types of things?
No, Your Honor, I think it's a great question. There's a raging debate, obviously, about nationwide injunctions and to what extent they're appropriate, to what extent they lead to dueling obligations on the government. This is a plaintiff-specific injunction. There's nothing inconsistent about the relief that plaintiffs are seeking here with the Walker and the Whitman-Walker cases. Those cases are about what does Section 1557 mean? What rules can HHS pass under it? This case is about, can those rules be applied to these plaintiffs? And the Religious Sisters of Mercy case from the North Dakota District Court just a couple of weeks ago addressed this very comedy concern that HHS had raised there and rejected it. And it said, sure, these are not conflicting obligations. HHS can have one rule for the non-religious people and a rule for the people that have already won the RFRA case.
Mr. Davis, are you aware of a case where we have held or other courts have held that a district court abused its discretion based on facts or law that developed after the district court's order?
So, Your Honor, the Opulent Life Church case is about abusing its discretion in not entering an injunction after finding, or in not entering an injunction for a meritorious RLUIPA or RFRA claim. As far as your precise question, no, Your Honor, I'm not aware off the top of my head of a case like that. But I think it's important to note that the difference between the vacatur that the district court gave us and the injunction that we're seeking here was obvious even before these events, these post-appeal events.
Tell me if this—
Excuse me, didn't Opulent Life, though, include events that occurred even on the very day before or the day of oral argument in that case? So it was, and doesn't the opinion discuss that? So it's not just events that were known at the time the district court did or didn't give the relief at the time?
That's absolutely right, Judge Elrod. The night before oral argument, the government there had changed its rule. And this court, in a really important passage for this case, said, well, look, for irreparable harm purposes, when you're evaluating that in a RFRA or RLUIPA case, the question is not what particular obstacle is it that the government has in place, the words on the page. It's the burden on religion. And there it was the plaintiff's inability to occupy their property. Here, it's the requirement that these plaintiffs will be required to give up their Medicare and their Medicaid funding, incur False Claims Act liability, all these penalties if they can't perform gender transitions and abortions because of their religious beliefs. I think the Opulent Life Church case is on all fours.
But Mr. Davis, I guess we should ask opposing counsel, is it a risk that these things are going to be required based upon the current state of the law and this understanding?
Yes, Your Honor. And I would direct the court to the Religious Sisters of Mercy case a couple of weeks ago, which went through all the reasons why right now Notwithstanding Judge O'Connor's nationwide vacatur, plaintiffs identically situated to the plaintiffs here continue to face a credible threat of enforcement under current circumstances.
But
And
do
that's
these plaintiffs, you pointed out the uniqueness of these plaintiffs. Do these plaintiffs, are they going to force these plaintiffs based upon the developments in the law?
Your Honor, I think that's what these plaintiffs are similarly situated to other plaintiffs that have religious objections to performing gender transitions.
But have they grandfathered them? Have they said, oh, we're not going after them and they have the right because of this lawsuit?
No, Your Honor. And I think the fact that HHS is still fighting this appeal the way that they are suggests that they want to preserve their right to go after these plaintiffs. I see I'm out of time, Your Honor, so I'll reserve my time for rebuttal.
Okay, thank you. We'll hear from opposing counsel now.
Good afternoon, and may it please the court. Ashley Cheung for the United States.
Ms. Cheung, does the government have any plans to be going after the plaintiffs in this case based upon the sex stereotyping or any other part of the 2016 rule at this time? Do they have to comply with the 2016 sex stereotyping provision, or are they grandfathered because of the relief that they obtained in the district court, such that it's not necessary to do any further relief?
Sure, I have a few responses to that, Your Honor. So plaintiffs prevailed in district court, and the district court vacated all of the provisions that plaintiffs challenged in the 2016 rule. Plaintiffs didn't challenge the sex stereotyping provision, so that's not an issue in this case. And the injunctions from DDC and EDNY, those courts did not purport to revive the portions of the 2016 rule that were vacated by Judge O'Connor in this case. So all of the challenged provisions are gone. They've been vacated by the district court, formally rescinded by the agency, and replaced by a new rule.
But I'm asking whether any portion of the 2016 rule, there's any intent by the government to use any portion of the 2016 rule against the specific plaintiffs in this case, because they also sought an injunction against the entire rule. They also sought an injunction against the application of the statute. And it was certainly news to the district judge and probably to you and the plaintiffs that the sex stereotyping provision could totally gut the relief that was given, but we learned that afterwards. So is there any current plan or is there an assurance that you are not going to enforce the 2016 rule against these plaintiffs? I'm trying to figure out if there's a controversy here that needs to be remedied, and then we can talk about whether they're entitled to a remedy, but is there even are they already safe or are they not safe under the 2016 rule?
Sure, so there is no current case or controversy here because the challenged provisions of the 2016 rule are gone and they haven't been revived.
But it's not just the challenged provisions. As we've learned, it's the rest of the 2016 rule that is come into play. And they were challenging the 2016 rule and also the underlying definitions in the statute.
Sure.
Is there government assuring us that it would not try to use the sex stereotyping language and the arguments that the district court developed in that case against these particular plaintiffs, or are they at risk under the 2016
Good
rule
afternoon.
Today?
Plaintiffs haven't met their burden to show any risk of enforcement.
I'm very sorry
to bring a pre-enforcement.
we weren't able to accommodate you in New Orleans this week. As it turns out, one panel
No, Your Honor,
of our court
it's
is
not the
having some
government's
arguments,
burden to
but,
do so. Plaintiffs brought this
since you were the
appeal,
only
and
panel
there's a
on
very
which
demanding
both
standard to
attorneys
bring a
signaled
pre-enforcement
your
challenge.
willingness
They
to
have to
show
show that
we
there's a
didn't think it made
substantial
sense
threat
for
of
us all to
imminent
troop
harm of
down there for
enforcement
that
against them.
purpose.
And they can't
But
show that
things are
here,
going
or they
to change
prevailed in
pretty
district
soon,
court.
I think.
And I do
So
want to be clear
that's
about
something.
exactly what case plaintiffs
We do
brought in
have a
district
couple of
court.
adjustments.
At every
or,
step of the process,
extra
they've been
rules of the
challenging
road
the
for
2016
purposes
rule
of Zoom
and not the
hearings. One
underlying
is we ask
statute.
you to
The underlying
silence any
statute
other
doesn't cause them any
devices you
harm.
have.
And I'd
or
like to
those
point the
people
court
in
to a
the
few
room with
specific
you.
examples.
Can we go back
Second
a
one
little bit
is
because
that
I'm not
we
quite understanding your
still
answer.
do
I
the
thought
audio
question
recordings
that
of
Judge
the
Elrod was
sitting, but
asking
we will
was
not.
pertinent to a case or controversy
As in
type
New Orleans, you're not allowed to
inquiry
video or
as
audio
opposed
them
to a
for
burden of
yourselves.
proof. I think you've answered it by
If
talking
you
about
like,
the plaintiff's
we
burden.
will give you
I
5
understood the
minutes
question, and frankly, I have the
uninterrupted
same
time at the
question as to
beginning
the
of your
case or controversy
presentation.
regarding the
Just because
2016 rule,
there's always a
which is
little bit
something
of a
I asked
gap
opposing
in
counsel right up
communication
front.
here.
So can
And
you
then
clarify
the other thing I would
case or
say is we will
controversy
appreciate in
question
both of your
before we
cases
talk about the
record
plaintiff's burden and
citations.
its likelihood of success and so forth?
We have a time clock system. The
Sure.
yellow
So
light
there is
will
no current case or
tell you that you have
controversy
2 minutes
under the
left, and when the
2016
red light
rule,
signals,
because
ask
the
you to
portions of the
conclude unless you're
2016 rule
answering a
from which
question from the
plaintiffs
court.
claimed harm
The sole
have been
case this
vacated
afternoon
by
is
the
number
district court and rescinded. And
220416.
plaintiffs have never claimed harm
Polyflow
from the sex
versus
stereotyping
Specialty
provision.
RTP.
So that
And we'll
provision
hear
is
from
not even at
Melissa
issue
Stratton
in this
to begin.
case. And they haven't
Thank you,
shown
Judge
that
Jones, and
the
may it please
agency
the
is
court.
going to bring any
The parties'
enforcement
contract
action
says
against
that
plaintiffs
any
under that
action
provision or
arising
under
out of
any
the
part of the
agreement
2016
must be
rule.
arbitrated.
Plaintiffs
In
prevailed in
this
district
action,
court on both
Polyflow
their
alleges
APA
that
claim and
appellees
their RFRA
breached
claim.
the agreement, giving rise to various contract and tort
And
claims.
just turning back
But the
to
district
exactly
court denied
what is at
Polyflow's
issue in this
arbitration
case,
request.
I'd
This
like to
court
point
should
to a few
reverse for
examples
2
from
reasons.
plaintiffs' complaint and from their
First,
district court
because
brief
the parties
to show that they
undisputedly
were
have an
challenging the
arbitration
2016
agreement,
rule
the law heavily
and not just a
presumes that
general
Polyflow's
application of the
action is
statute.
arbitrable.
So the first
To
sentence
deny
of plaintiff's
arbitration,
complaint
this
says,
court must have
this
positive
lawsuit challenges
assurance
a new
that the arbitration
regulation
agreement
issued by
cannot be read
HHS,
to cover
and
this
that's the
action.
2016
There
rule.
is at least no such
In
positive
count
assurance
1,
here.
paragraph 121,
Second,
they
appellees'
say
merits
the
defenses
regulation
and
is not in
procedural
accordance with
arbitrability
section
challenge are for the
1557
arbitrator to
or
decide,
Title IX.
and thus may not
In
preclude
their prayer
arbitration.
for relief, they ask the
To
court to
begin,
issue
the scope
a
of the
permanent
arbitration
injunction
agreement here is
enjoining
reasonably
defendants from
construed to
enforcing
cover
the
this
challenged
entire action.
regulation
The
against
settlement
plaintiff.
agreement requires
And the
arbitration
same goes
of
for all their
any
district
action
court
that
briefs.
arises out of the
So the
agreement.
point here
The
is that
plain meaning of action
plaintiffs
is
challenged the
lawsuit, the entire
2016
civil proceeding.
rule, and
So
they
the
won
parties
on that
agreed to
challenge.
arbitrate
They can't use
the
this
entire
appeal
civil
and a challenge
proceeding
to
if
the
it arises
2016
out of the
rule
settlement
to
agreement.
challenge different
this
agency
lawsuit
action,
qualifies.
which they never raised in district court.
First, this
Well, I guess that
lawsuit
gets us
exists
back to the
because of the
point, what
settlement
does it mean
agreement.
to have
And the first
won the
page of
challenge?
Polyflow's complaint
Because the
at
court explained
1189
that
of the
there was no
record on appeal
indication
makes
that
that
once the
clear,
rule was
stating
vacated,
that Polyflow is bringing this
defendants would defy
action
the court's order
because
and
the
attempt
parties
to
entered a
apply the
settlement
rule
agreement,
against plaintiff.
but appellees have not complied with it
Indeed,
and
the
never
defendants agreed
intended
with
to
plaintiffs in the
comply.
court that the rule was substantive.
Second, this lawsuit includes claims that appellees concede arise out of the agreement. Specifically, Polyflow's claim and appellee's counterclaim for breach of the agreement.
Considered vacated.
So because this
And in
action
fact,
unequivocally includes claims
another
that arise
court
out of the
has
settlement
said
agreement, and
that
indeed, the
the
lawsuit only exists
stereotyping
because there is a
provision
settlement
must
agreement that
be,
we
in
allege has
fact,
been
and is
breached.
enjoined
The
from
action
being,
arises out of the agreement. And the
vacated.
plain language of the
And
arbitration
that
clause
provision
thus
does the
requires
exact
arbitration
same thing
of the
that
entire
words that were
lawsuit.
vacated or marked out.
And
So
this
it's
court
not
employed
correct,
that reasoning
technically, that
in
the
its
rule
2019
itself is
decision in
vacated.
Archer, which
The
we've
rule
cited
is
to the court
still
as supplemental
in effect,
authority.
At least in part.
The Archer panel
And it has the
focused
same
on the plain
substantive
meaning of the
effect
term
to harm
action,
the plaintiff,
which meant the
unless
entire
the
lawsuit,
defendants,
not just
are
individually qualifying
acquiescing
claims.
that the
And it
plaintiffs
refused
are not
to
subject
rewrite
to
the
that
arbitration agreement
injunction in
there
the Whitmer
to encompass
Walker
only
world.
individually qualifying claims.
So the district courts
And I think it's
in
important to
Walker
note
and in
that
Whitman
the
Walker
reasoning
both
that Archer
recognize
used
that they did not
applies
have the
with
power
even more
to
force
revive
in this
portions
case,
of the
because
rule
there
that were
Archer
vacated by the
involved an
district court in this
exclusion
case.
from
But
arbitration.
So that's it.
So the plain meaning of
they
action, the
revived other
exclusionary
portions that
language,
they
had to
said
be
did
enough
this-
to
one of the
overcome
courts said did
a
the
presumption
exact
in
same
favor
thing,
of arbitration.
So it was of no account.
Here, the
I don't
plain
think it's
meaning of
clear
any
that that
action
provision
governs what is
does the exact
included
same
in
thing.
arbitration.
If it
So
did, then
this
plaintiffs
case,
should have
the
challenged that
contract's
provision
plain language
in their
and the
case in
presumption
district
in
court, and
favor
they
of
did not.
arbitration
Plaintiffs
are
still
rowing
aren't
in the
claiming
same
harm
direction.
from that provision.
Now,
And the district court was well within its discretion to craft appropriate relief in this case for the APA claim
and specially defines action to more narrowly mean only claim.
Courts are supposed to award appropriate relief, and that doesn't always have to be an injunction. And
you can see the settlement agreement at tab 4 of our record excerpts.
There
and
was
if you
a
look in subsection A on the very first page, you'll see that the settlement agreement does not define the term
So the first
action.
is Tanzin
So under ordinary
versus
contract
Tanvir
interpretation principles, the plain
Supreme
language
Court,
of the
it's
term
141,
should govern
Supreme
lawsuit,
Court
entire civil
486.
proceeding.
And
What
the Supreme Court
agreement
explains
does
that
define at
appropriate
A1
relief,
is the
that term is
claim.
open-ended on its face.
And it defines it
and what
because
relief
it's going
is
to use that term
is
to describe
inherently
what is being
context
released
dependent.
by the parties
And in that
this
case,
settlement agreement.
monetary
and
damages
so
for the
it defines
appropriate
claim
relief in
expansively
an
to
individual
include
capacity
not
RFRA
only
claim,
claims, but
not
also
an injunction.
demands, actions,
And the second case
causes of
is
action,
OA
so on
versus
and so
Trump,
forth.
which was
All
cited
that
by the
this
district
means,
court in
however,
this
is that
case.
when the settlement
And the
agreement
court
uses
said
the
an
word
injunction
claim,
was not
it means to
warranted
incorporate a
because
more
that court had
expansive meaning.
vacated the
It
challenge
does
rule.
not mean
And that's
that when
exactly
the
the
settlement
situation
agreement
we're in
uses the word
here.
action,
Could
as
you
it does in
please,
this arbitration agreement,
let us know
that the
how
parties
you would
intended to more
distinguish the
narrowly
opulent
constrict the
life
plain meaning of that term
language about
to
the
mean
RFRA
only claim.
injunction,
And in
and
fact, Your Honors,
also,
A1
why
of
it
the
would
settlement
be
agreement that defines
wrong
claim
to
shows the
just
parties
remand and
understood
let the
there is a
district court
difference
look at the
between the word
situation
action
in
and
light
the
of
word
the
claim
development.
because they define claims to include
So I think a remand would be
actions, and
inappropriate
causes
in
of
this
action,
case
showing that they
because
understand the
this case has
difference.
already proceeded
So
to final
we
judgment.
contend
Plaintiffs
with the
won,
support
and the
of
district
Archer
court
and
rightly
other
pointed out
authorities
that
that
if
this
there's
any
future
action
agency
clause
action
is
or different
unambiguous,
agency
and the
action that
entire
threatens
lawsuit
imminent
must
harm
be
to
arbitrated.
plaintiffs,
But that
plaintiffs
is
can
at least
come
a
back to the
reasonable
courts and they can seek
interpretation
relief
of
at
the
that point.
arbitration agreement.
But as this case
And so in that
stands,
case, the
there's no
standard for
current
denying
case or
arbitration is not
controversy
met
over
because this court can
rule
have
that
no
plaintiffs
positive
challenged.
assurance that this agreement is incapable
And the district
of
court
being
was in its
read
broad
to cover this
discretion to
action.
do that. And I would like to
turn now, unless the court has questions about the scope of the arbitration clause, to appellee's asserted
I'm sorry,
defenses.
are we having a?
Let me ask you one
hearing
question.
issue?
No.
When you say
No, I'm
arbitration
sorry.
clause,
Opulent life.
the settlement agreement has two paragraphs discussing arbitration. Are you referring to B5C
Sorry, was
or
there a specific
C4,
portion of
or
that case
how
that
are
you
we
wanted me to
supposed
address?
to interpret those
Yes, it
provisions
said that a
together?
RFRA injunction should be entered.
C4 is the clause that I'm referring to. And
Whenever
Polyflow's
RFRA is
position is
violated.
that based on the text and
That's the portion that
context
I
of the settlement
would
agreement,
like
that
to address.
C4
Sure,
is
but
the arbitration clause.
sometimes an injunction under
B5C
RFRA
is essentially
the
belt and
appropriate relief
suspenders. It's
for that
additional
case,
language
but as
that
the
also
Supreme Court said
underscores
in
the broad
Tanvir,
intent of
it's
the
not
parties to
always the
arbitrate
appropriate relief.
a
And
broad
here,
range of disputes.
it was
and
well
so when
within
I'm
the
referring
district
to the
court's
arbitration agreement,
discretion
I'm
to
referring to
conclude that
C4,
by
but
vacating the
B5C,
challenge
as we
provision
argued
of
in
the
our brief,
rule,
is
that
further
sufficiently
support
protected
for
plaintiffs
the
and
argument
that no
that there's
further
no
relief was
positive assurance
warranted.
that the parties
And I
agreed
think the
to
Supreme
exclude
Court's decision
any
in
of the claims in this
Monsanto
action.
is exactly on point here. In that case, the district court had vacated the challenged agency decision.
I'll turn now to
and it had gone
defenses.
one step further and
This court
entered the
should
type of
hold that the
injunction
issues
that
of
plaintiffs are
release,
asking for here.
prior material breach,
And the Supreme
and
Court
lack
said
of mediation
that second step,
are for the
that
arbitrator
injunction,
to decide.
was an abuse of discretion.
This court's
because if
inquiry,
there was
when
future
faced with a
agency
request for
action
arbitration,
that might
is
harm
very limited.
plaintiffs,
The
the
court does
appropriate
not
thing
address
to
the
do
merits,
would be for
but
plaintiffs
asks
to bring a
only
challenge
whether
to
an
that
arbitration
action
agreement
at
exists
that point,
and whether
not
the
for the
subject
district
matter of
court
the
to
dispute
enter a
is within
preventative
its scope. Where the
permanent
existence of the
injunction
contract
against
is
future
not at issue,
hypothetical
as
agency
here,
action.
the only
don't know.
defenses a court may consider are those that specifically relate to the making of the arbitration agreement itself.
The 2016
Defenses that
rule.
apply to the
Because
continuing
nothing else-
enforcement
the
of the
agency
contract
doesn't
as a
need to
whole
do anything
are for the
else
arbitrator to decide
except
as part
to
of the
apply
merits
the
of the
provisions of
underlying
the
dispute.
2016
This court has held that
rule
repeatedly in
are still
Primerica
effect.
and Bank One, in Will Drill,
So two
and the
responses
Supreme Court
to
has
that,
held
Your
the
Honor.
same in Prima
First,
Paint.
there's no threat of
Here,
enforcement.
appellee's
The plaintiffs haven't
defenses
shown that
that
the agency
Polyflow has
intends to bring
sued
an
on
enforcement
released
action
claims,
against them under
or
the
that Polyflow
2016
has
rule.
committed a prior material breach of the settlement agreement by firing the neutral
You said
pipe
two.
expert.
Did you-
These
you
are
can
not
give your second
independent
response, and I
attacks
think
that
Judge
solely
Willett
relate
has
to
a
the
question
arbitration
for you as
agreement,
well.
but they
Or
are
was it you, or
merits
was it Judge
defenses
Willett?
that
I think
go
it was you,
to
Judge
the
Willett.
enforcement of the contract
Sure.
more
Did you
generally.
want to give your
And
second
appellee's
reason?
answer illustrates
Yes,
that. Their answer in the district court, which this court can find at Record on Appeal
future agency action. There has to be some concrete
and I direct the court
case or
specifically to
controversy
paragraphs
now.
3
So to the
and
extent
15,
that they think the
make
agency
it clear
is
that
going
they
to
have
take
pled
different
both
action in the
release
future,
and
They
prior
can bring
material
that claim
breach
in the
as
future.
affirmative
They can't get a
defenses to
permanent
Polyflow's
injunction
claims
now.
on the merits, as well as using
I
both
think Judge Willett
release
has one
and prior
question
material
for you.
breach in the form of
I do. Thank you.
allegedly
Just really
firing
quick,
the neutral
it's
pipe
about Whitman
expert
Walker.
as a basis for their
So the DC
counterclaim
Circuit,
for
we all
breach of
know,
contract.
just stayed the
So
appeal
it's clear from their answer
the
that these
preliminary
issues,
injunction against the
release and
2020
prior
rule.
material breach, these are
And I think
merit
just
issues
awaiting
for the arbitrator and
possible
not defenses to the
reconsideration,
making of the arbitration
of the rule
agreement
by
for
the
the
new
court.
administration. And I
Ms.
wanted the
Stratton,
government's
so
thoughts
let me
as to
move back to your
any
first issue
implications
for
of
a
that.
minute.
Should the agency's reconsideration
Let's
of
assume
the
there's a
2020
textual
rule
argument in the
inform how we view this
arbitration
case?
clauses for looking
Sure.
at
So I
these,
think the fact that the agency is
complaint
reconsidering
or
the
looking
issues
through to your
only underscores that there
causes
is
of
no
action or
current case or
whatever on a
controversy, and
piecemeal
that plaintiffs
basis.
are not harmed
One
now
of
by
those
anything that the agency is currently doing
fraudulent
or under the
inducement to
agency's current
settle.
interpretation of the rule.
How do you square that?
And if the court
with,
has no further questions, we would ask
arbitrating
the
the
court to
contract?
dismiss this
And
appeal as moot
also,
or to
what
affirm
about
the
the
judgment of the
tortious
district court.
interference
Thank you.
claim? How does
Thank
that
you. We have your
arise out
argument.
of the
Mr.
settlement agreement?
Good morning, Your
So
Honor.
I'll
It's
turn
Joshua
first to the
Block,
fraudulent inducement
intervener.
claim.
I think
It
today
arises
has
out of the
blended
settlement
together
agreement
two
for the
very
following
different
reasons.
questions, and I think
First,
it's important to keep
under
them
Texas
separate.
law,
The
a
first is
fraudulent
whether the
inducement
plaintiffs are
claim
entitled to
cannot
an
exist
injunction against the
but for the
2016
fraudulently
rule.
induced
And the
contract, and
second
it
is whether
requires
they're
the
entitled to
existence
an
of that
injunction that
contract
goes
as part of
beyond
its
the
proof.
2016 rule
Our
to
claim is
cover
even more
hypothetical future
dependent
agency
upon the contract
regulations that
because
haven't yet
in
been
paragraph 80
promulgated.
of our complaint,
Now,
we
the
allege
first
that
question,
it is
I think, is actually a
misrepresentations
relatively
in the
low
settlement
stakes
agreement
question.
itself that
As we see
fraudulently
it,
induced
the
us to
district court
enter the
issued a
contract.
declaratory
And
judgment.
I'd also direct the
This is in
court's
its final
attention to the
judgment on
following
Record
decisions:
Excerpt
Prima
41,
Paint,
declaring
Henry
that
Kaplan
the
from the Texas
2016
Supreme Court,
rule, as
Gurwell
applied to the
from the
plaintiff,
Texas
violates
Appellate
RFRA.
Court, Sweet
That is a
Dreams from the
binding
Seventh
judgment
Circuit,
on the
as well as
government.
this court's own decision in
And
Marlin,
so
which
I
involve
think the issue
broad
for this
and
first
narrow
question is whether or
arbitration
not that
clauses. And the
declaratory
courts held
judgment
in all
is
of those
enough, or
cases
whether
that
they need an
fraudulent
injunction
inducement claims
too.
were arbitrable, whether
And
the
as
clause
interveners,
was broad or
we
narrow.
don't really care as much about that
As for
answer
the
to that
tortious
question, because I
interference
think in
claim, Your
either
Honor,
case, the only
these
issue is
claims
whether the
are
government is going
specifically
to be under the
predicated
court's
on
contempt power
misrepresentations
if they
and
bring another
omissions
action
that
under
we
the
allege
2016
appellees
rule.
made to third
But
parties about the
it's
settlement
clear
agreement
that the court has
itself.
held the 2016
These
rule
misrepresentations and omissions are pled at
these
paragraphs
defendants. And I think
64
that's
and
true.
68
right? That's in
of our
total,
complaint,
not just the.
and they are
and that
incorporated by
includes the
reference
sex
into our causes of
stereotyping
action
provision
at
because it's the
paragraph
entire
70.
rule. Is that
Yes,
your
And you'll also
understanding?
find them
Yes, Your Honor, that is
incorporated
my
by reference
understanding.
into the
That the
tortious
EPA
interference
challenge
claim
is
at
to
paragraph
the specific
117.
provisions, but the RFRA challenge,
And so we
I
allege that
think,
the
was to
breaches
the
of
entire
duties
rule.
imposed by the
So you're
settlement agreement, the
agnostic
use
on
of our
whether or not
information,
we need
the misrepresentation about our
That's
relationship
right.
is what
That's right.
caused tortious interference with
I
business
don't think it was an
relationships.
abuse of discretion.
And this court
I
has
think
made
in
clear in
general, the
numerous
Supreme Court
cases,
has
as
said
have
that when
Texas
voluntary
courts,
cessation
that a
happens,
breach
as
of
with the Trump
contract can
administration,
involve
that
tortious
generally
conduct
counsel
that
in
gives
favor of
rise to both
declaratory
breach of
judgment and
contract
not an
and tort claims
injunction.
at the same time. That's what's
I
happened
guess
here. It's why
in
our
light of the
tortious
statements
interference
today, the
claim
court might
arises out of this
ask
contract
the court
because
to
it is
remand.
generated by appellees'
My
alleged
understanding is that
breaches
any
of the
application of the
contract.
2016 rule against these plaintiffs
Do you
under
have
the
any
district court's holding violates RFRA.
idea
And now you're
why
going to talk
Judge
about the
Boyd
statute and the
disposed of
2020
this
provision? Is
in
that
one
how you're going to
sentence?
break it up? Or
And I'm
however
looking
you-
at the docket. It looks
whatever.
as if
No, Your
there
Honor.
was no
So
oral
I
hearing
think that the 2020
on the
provision
arbitration agreement.
is
So
a little bit irrelevant to this also.
I do not know. That's quite a
To the
mystery
extent
to
the
us as
2020
well,
provision revives
particularly
anything
given
about
the strong
2016
presumption in
provision,
favor of
it can't be applied to
arbitration
these
and the
plaintiffs
broad
under
language here
RFRA.
under numerous court
So I don't
precedents.
think it's the vacatur that
So his
protects plaintiffs. It's
summary
their
denial of
declaratory
arbitration
judgment that
is
this
quite a
violates
mystery to
RFRA.
us, and it's
And they're
why we're
not
here.
similarly.
Vacatur is
I don't
not
know the
really
answer,
strong
unfortunately,
enough, is
Judge.
it?
I think it's a red herring.
I would
think
like
that it's
to
the
turn and
declaratory
discuss
judgment that really
failure of
provides them the
mediation now.
protection, and that's what distinguishes them from the Sisters of
Mediation
Mercy
is a
case.
question
They
of
brought a lawsuit.
procedural
They didn't have a
arbitrability.
declaratory
And
judgment
procedural
already protecting them.
arbitrability
But
is a
I think what
question
is of
for the
great
arbitrator
concern
in
is
nearly
the
all
idea that they could
circumstances.
leverage
This court
holding
has
against
found
the
that there's only
2016
one rare
rule
exception
to have
in which
an
the court
injunction
can
that
decide a
purports to
procedural
enjoin
prerequisite
application of
bars
regulations that
arbitration,
haven't even been
and that is when it is
adopted yet.
clearly established
In
that a
their
procedural
footnote,
requirement
in
is
footnote
a
4 of
condition
their
precedent to
reply, they even
arbitration
suggest
and has been
HHS would have
breached,
to
such that
effectively
no
have
rational
pre-hearings for the
mind could
district
conclude
court
otherwise.
before applying any sort
That
of new
high bar
regulation.
for taking
And,
this
that
question
might
of
be
whether
efficient. It's
mediation
always
is a
efficient to have
procedural bar to
advisory
arbitration
opinion, but
has
Article
not
3
been,
courts can't
for
do that.
taking that
They
question from the
just can't
arbitrator, has
enjoin
not
the
been met in
application
this
of future
case.
regulations
Because
that
a
haven't been
rational
passed.
mind could agree with Polyflow
you challenge
that
the
mediation
regulation
is not a
after
condition
it's
precedent,
not while it's still
or
being
that
drafted.
if it is, it's been either deemed fulfilled or excused by appellee's conduct frustrating mediation. And before I tick through those reasons very briefly, I'd like to remind the court that under General Warehouseman and other precedent, this court doesn't need to agree that Polyflow would prevail on any of these points. It need only conclude that a rational mind could agree and that these issues are not clearly established, such that it's the arbitrator's province to decide whether mediation is a bar. Mediation is not a bar and not a condition precedent because it's disfavored under Texas law.
It's nowhere in their complaint.
I'd note that at page 30 of their brief, appellees have reversed course from their position in the district court, and they've argued to this court that mediation is in fact not a condition precedent. That seems at least suggestive that a rational mind could agree with Polyflow.
It's completely absent from anything.
The settlement agreement's mediation terms only apply to issues of B1 and B2 compliance. They don't apply to the other types of issues that are in dispute here. And even as to B1 and B2, they only apply when the pipe expert has made a determination that the appellees are out of compliance, which appellees concede never happens here. But even if it is a condition precedent, it's been deemed fulfilled by their failure to specifically deny it in their answer. But even more importantly, it's been frustrated by appellees withholding of their design and manufacturing process information, which is the earlier step necessary to even get to mediation. And this court has held that a promisor cannot take advantage of a condition, a failure of a condition that they themselves frustrated. And I see my time is ending, so I will reserve the remaining time for
there was irreparable harm from a
Thank you,
RFRA
ma'am.
violation.
We'll
I don't think
hear
there's
from
any
Mr.
dispute. A RFRA violation
Schlager.
is irreparable harm. I think an injunction isn't
You're
necessarily
muted.
necessary here
There you
because
go.
they have a declaratory judgment to stop it
Thank you, Your
already.
Honor.
Not that the harm
May
if
it please the
happened
court.
wouldn't be
My name
irreparable.
is Steve Slather,
And I
representing
just
the
wanted to
appellees here.
emphasize that beyond,
I think
a very
a brief
weighty
background
Article
here will be
3,
helpful to
questions here, having a
understand
broader
kind of the
injunction that
context
goes
of the
beyond,
settlement agreement.
for regs that haven't been passed yet.
Mr. Wright,
The court has
one of
said
the
time again that any
defendants and
injunction has to be narrowly
appellees
tailored to the
is,
specific
was
violation
the
of the law
developer
that the
of
court
the
found.
technology that's
And
kind of at
plaintiffs
the
here, they
center
won a
of this.
RFRA judgment.
He founded
on
Polyflow. He was a
expedited
CEO
basis
for a
without
time,
any discovery,
developed
without
its
any
product during that
lodging
time.
of the administrative record.
At some point, the
district
parties
court was
went their
willing
separate ways.
to,
Mr. Wright
sort of
set out
accept the
to
government's
form
default
Specialty
on this.
RTP, where he
I think that
remains
allowed
today.
a much
and
quicker
Polyflow
resolution than
continued
if the
with its
court had purported
business.
to issue a holding for all time.
You've
that
seen
any
reference, and we
application of RFRA
discussed it in our
couldn't
brief,
provide
that
any sort of,
in 2015, Polyflow
any application of
brought
the rule could never
claims
provide
against
any
Mr.
RFRA
Wright
analysis,
and
regardless of what the evidence actually
SRTP.
showed.
And in fact,
whole
those
theory of the
claims
case
are largely the same claims they bring now in this case.
Very broad injunctions on just
that suit was ultimately resolved. It was
swaths of regulation and
really best
proposed
described as a
regulation
nuisance suit, and that's evidenced by the
you're
fact
aware of
that
right?
if you look at the
Your Honor, I
settlement
guess
agreement,
that's
no money
really a course
changed
of
hands
appeal.
there.
All these decisions are in the past
The
2
part
years.
of that agreement
And I
is
think this would
sections
be the first court of
B1 and
appeals to ever
B2,
bless
and those
that
put
sort of injunction, and
restrictions
it's really
on
unheard of.
specialty RTP with regard
I see my-
to what information
I'm
it
sorry,
can
were you
use and
finished? I
what
didn't mean to cut you
products
off.
it
I was.
could
I'm happy to answer
design
any
or
further questions. I
manufacture.
just saw that my time was up.
Mr. Wright and
Thank you.
SRTP have never used
I don't think there are any
Polyflow
further
information,
questions for you, but we
but the
appreciate
agreement
you.
provided that there was a mechanism for Polyflow to
Mr.
confirm
Davis, you may
on an ongoing
proceed with your
basis
rebuttal.
whether
Your Honor, just a
any
few
of
quick points in rebuttal.
SRTP's
So first, we heard from both
products did
HHS and
include,
ACLU that this case was a
Polyflow
challenge to a rule and not a challenge to a statute.
particular
But
importance
Your Honor,
to
again, in
Specialty
the
RTP
injunction that we submitted,
was
the proposed injunction language that we
dispute
submitted to the district
resolution
court, which is the
framework
best
set
place to
forth
look for the
in
relief that we were asking the
sections
district court to give us.
B4 and
We specifically
B5
sought
of
the
the
very
agreement.
relief that we're seeking from this court.
And what
The
those
best
call
place to look
for
could be your
is the
complaint,
appointment
or
by an
maybe in your
arbitrator
briefing,
of
it
what's
also,
referred
I
to
mean,
as
did you
an
bury that?
RTP
And it's not
expert or a
really
neutral
wasn't
pipe
front and
expert.
center.
And that
It's not
was
a
a
criticism, it's
person
just
that was
can we be
neutral
realistic
and
about
also
what did you
knowledgeable
really
about the
argue to the
technology
district court?
and the products
Sure, Your
that
Honors,
were
and,
involved
Your Honor, and
from both
just wanted to
Polyflow
clarify.
and
Of course, there are two
SRTP.
different main pieces to this
that
case. There was an
framework
APA piece, which
requires
said
that
this
the
2016
pipe
rule is
expert,
inconsistent with the underlying statute.
examine
That's, of course,
any
what
products that
HHS was
Specialty
quoting when they
RTP
talked about
intended to
the complaint.
manufacture
There's a RFRA
or
piece that said
design
it's not
for a
about
time
whether
period
the rule
and
is
make a
consistent with the
determination
statute. It's
of
about whether the government can take this action. It's a substantive claim. It's not a procedural
B1
claim.
or B2
Can the government
of
require
the settlement
plaintiffs
agreement.
to perform these procedures?
And the reason this framework was set up
holding
this
these
way, and the
penalties
reason
under
that there
Section
was a
1557
neutral
over their head.
expert put
That
in
claim
place
assumes
was
that
because
the rule is consistent with the
especially
statute,
RTP
and then
was
asks, can the
particularly
government do it?
concerned
So
that
this is contraceptive mandate
would
land. This is
use,
exactly what the plaintiffs
this
asked for in the
mechanism
contraceptive mandate case,
to,
and what they got in at least 20
to
contraceptive mandate
discover
cases
or learn
that we
about
collected in our brief.
specialty
I'd also direct the court,
RTP's
Your
technology.
Honor, just in case the court
And so
still had
that's
lingering
why they
concerns about
had this
that,
neutral
there's a
expert
federal
in
rule that's
between
directly
so
on
that
point, and that's Rule
neither
54C.
party's
And it says the judge is supposed to, the
information
district
would
court
ever
is
be
supposed to give the
shared
plaintiffs
with the
whatever
other.
relief
It would
they're
all go
entitled
to
to
the
as a matter
neutral
of law,
expert. He would
even
make
if
a
it's not in the
decision,
complaint.
and
I think our complaint makes it quite clear
the information
that
would
we're challenging a
remain
burden with respect to our RFRA
separate
claim,
from the other
not
party.
words on a page, but there's that rule to fall back on if the court needs to look
Going
to that.
forward,
Mr. Davis, what threat of enforcement?
the pipe expert, once he made a decision, and as Ms. Stratton noted,
I think that's a
if
key
the
question, and the
decision
Religious
was
Sisters of
in
Mercy case
favor
goes a long
of
way to
specialty
addressing it. But
RTP,
to answer your question, under the speech first precedent from this
decision was
court,
final.
and under
Only
numerous
if
pre-enforcement
he
challenge
found
cases like the
that
Susan B. Anthony versus Driehaus
specialty
case,
RTP was
the
in
question is a
violation,
credible threat of enforcement.
would it
And
then
the speech first case
trigger
points out that in the
a
ordinary
mediation
case,
process,
that credible threat
and
of
the
enforcement
pipe expert
simply
would attempt
follows
to
from
mediate
the fact
that
that the plaintiff's
dispute,
conduct is at least arguably
and
prescribed
only if he was
by the challenge
unsuccessful
statute,
in
as long
mediating
as that
that
statute is
dispute,
non-moribund.
would the
Of course,
parties
there's no
then
claim that the
agree
statute here
to take
is
that
moribund.
dispute
But in terms of the
to
actual facts on the
arbitration?
ground,
And that is
there's a credible threat of enforcement for
the
several
arbitration
reasons.
provision
So
that you
tell me
see
how-
in
tell me
section
how
B5 of the
uncertainty- tell me
agreement,
how
and it is specifically
possible
related
harm
to
equals
these
irreparable
disputes
harm.
that may arise
so, Your Honor,
in
I
the
think
context of the neutral pipe
possible
expert
harm,
and
uncertainty,
sections
all of that
B1
sort of
and
goes to
B2
can the
of
plaintiff
the
bring this
agreement.
case at all in
But
the first place, and that's what
the
HHS has been
important
arguing.
part of that is
the
that
appeal is moot.
the purpose
we think
was to prevent
it's simply
specialty
very odd to say a
RTP's
claim is
technology
mooted
from falling
by the
into
2020 rule, when
Polyflow's
the
hands
2020 rule has
under the
been
guise
enjoined,
of policing
and the
the
2020
agreement.
rule itself arguably
The
imposes
second
same requirements
arbitration
on us. So that's
clause
the mootness
here
question.
is
But I think Opulent Life Church
found in section
tells you
C4
that once you get over
it
the
relates
justiciability
only
hurdles,
to
you get to the merits and you
disputes
win your case.
that
RFRA or
arise
LUPA,
under
you have
the
shown
agreement.
irreparable harm.
And
So I think it's
that's
important
very clear that
to really understand how
I
that
think,
works. And I'd also
on
direct
that
the court
point,
to the Diocese of Brooklyn
the
opinion
courts
from
are
the
clear,
Supreme Court,
including in the Pennzoil
just
case,
a couple of months ago.
that
And there, it was not a mootness case, it was an injunction
arbitration
case.
clause that
The plaintiffs
uses
had been
language
removed
such
from the
as
challenge
arising
requirements
out
by the
of
time the case got to the Supreme
is
Court.
a narrow clause.
And so the Supreme Court had to consider,
the court in
should we still
Pennzoil
enter an injunction
contracted
here?
that
And the court
with
did enter
broad
the injunction
clauses
because it said the
that use
plaintiffs were under a
language
continuing
such
threat
as
that the
arising out
requirement,
of or related
the requirements could
That's
be
clearly
reimposed
not
on
what
them.
we have here.
That's this case. And I want to be
under
clear, Your Honor.
Pennzoil, the clause in C4
Well, you
is a
said that there
narrow
were
one.
practical and you didn't get to those.
That's further
Yes, Your
evidenced
Honor.
by the
So,
fact that
even aside from
the
the point
clause in
that
C4 does
a
not
RFRA
even
violation
cover
is irreparable
all
harm. Here,
disputes
there's a
that would
credible threat of
arise
enforcement for at
under
least
this
three reasons.
agreement.
The first is that back when the
as I
2016
mentioned,
rule was originally passed,
separate
HHS
dispute
vigorously
resolution
enforced it,
mechanism set forth
including by
in
entertaining claims
section
against
B5
Catholic hospitals,
would cover
exactly like
disputes
the
that
plaintiffs in this case,
fall under
claims that were
sections B1 or
complaints that were
B2
brought
of the
by
agreement.
counsel for ACLU.
Well, I might
or by
agree
ACLU
with
in
you
this
if
case.
the
Second, and so there's really no reason to think that HHS won't go back to doing what it did now that the 2016 rule is back in effect
limited to this
under
agreement
Walker
or this
and under Whitman
mechanism,
Walker.
but
Second is even independent of the
instead it
2016
says
rule,
for purposes
plaintiffs
of
around the
clarity,
country
the
have
parties
brought
are
lawsuits
agreeing
against healthcare
that
providers
any
similarly situated
disputes
to the plaintiffs in
arising
this
out
case
of or
under Section
related to
1557
this
itself,
agreement
not
will
under the
be
2016 rule.
arbitrated.
We can rattle off at least 8 cases that are cited in the record
And
below,
is
or that are
are
cited by
we,
Justice Alito in his Bostock opinion.
And going
And
a
those
little
cases have
further,
been successful. They've
aren't
either
we
gotten to
required
discovery
to
or the plaintiffs have actually
interpret
obtained
these
injunctions
provisions
under Section
harmoniously
1557,
and
not the
not
2016 rule.
one
plaintiffs have been
limiting
living
the
under
other
a sword
or
of
being
Damocles
limited
for at least 4 years.
arbitrarily,
This is the third administration
as
that this
opposed to
lawsuit has
the
been
other
pending
one.
against. And every day they're piling up potential new liability under the False Claims Act, as the North Dakota District Court pointed out in its opinion in Religious Sisters of Mercy a couple
I
weeks
think
ago.
they do need
So
to
we'd ask the
be
court,
interpreted
Go ahead and wrap
harmoniously.
it up. I think your time is up.
I'm sorry,
and
Your Honor.
we'd ask
I
the
think
court
they do
to
need
reverse
to
the
be
district court's remedy
interpreted
determination in part
harmoniously seriously. And I think the way that that is done in this case is that you look at you look at the agreement as a whole, and specifically in sections B4 and B5, it sets forth this dispute resolution framework that relates to, as I mentioned, the neutral pipe expert and his duties to resolve disputes arising under sections B1 and B2. And then if you look, C4 then would cover anything else. And so otherwise you would, if you read section B5C broadly to cover all disputes that arise under or relate to the agreement, you end up rendering the clause in C4 a nullity. And that's what the parties intended here was that agreement or that clause in B5 would relate to the dispute resolution framework of sections B1 and B2, and that C4 then would cover any other disputes that arise under the agreement.
Well,
so with regard to
what's your best case? What's your best case?
With regard to
you and I, your transmission is a little slow. I'm sorry, I don't mean to interrupt you.
I apologize, and I don't. It does drop occasionally, and I'm not sure why.
Well,
I think just the plain reading of the agreement, as you mentioned, requires those two clauses to be harmonized, and the agreement itself makes clear how to do that. Because it sets forth the framework for dispute resolution under B1 and B2 in sections B4 and B5. As I mentioned, where you have two competing clauses, and in this case they don't compete. But if you did try to read them on top of each other, one would just be rendered a nullity, and that shouldn't be the right result here. Further, I believe I understood Polyflow to say that they are seeking arbitration solely under C4 in this case. With regard to the argument that all claims, if any claim is arbitrable, all claims are arbitrable, and that's Polyflow's argument with the Archer case. Here again, the agreement makes clear that certain disputes, those arising under B1 and B2, do not fall under the arbitration clause in C4. And so at least one category of claims would not go to arbitration, even under that, or should not go to arbitration under Section C4. That's not what the parties agreed to. They agreed to have two separate arbitration provisions covering different aspects of the agreement.
So is it your position that you want part of this dispute arbitrated and part of it submitted to the federal court?
Well, we believe all the claims should properly remain in front of the court, and that none of them are arbitrable. And
well, you just said that B1 and B2 are arbitrable.
They are if and that goes to whether certain conditions are met, and as we describe in our briefing, those conditions just simply haven't been met. There's a framework, and it requires the appointment of an MPE by an arbitrator. That was done, and it requires the pipe expert to then examine SRTP products to see if they are in violation of sections B1 or B2. He's done that. In this case, he has not found a violation, and therefore, under the terms of the agreement, that's the end of that inquiry. However, if there was a case where he found SRTP to be in violation, only then, if he was not able to mediate that dispute, would that specific dispute go to arbitration under the provision in section B5.
Well, I mean, they assert that a number of their claims, they assert
in that way, then.
Okay, I'll try again. they assert that a number of their claims are based on disclosures of information contrary by specialty RTP, contrary to the settlement agreement, interference with customers of Polyflow, and Lanham Act violations. And it seems to me all of those are reasonably read as being governed by the settlement agreement. So why are they not arbitrable under C4?
Well, if we look at the Ford case, for example, the test for whether tort claims arise or relate to the agreement is whether those claims could stand alone. And so certainly the Lanham Act claims, which relate to trademark trade dress largely, those claims could certainly stand alone here. The existence of the agreement is not required to go forward with those claims. With regard to tortious interference, it's the same. The activities that Polyflow complains about which was disclosing information to certain customers, setting aside that may not even fall under the Lanham Act because it doesn't relate to goods or services. That cause of action would stand alone. It does not require the existence of the contract. And the same is true with regard to the fraudulent inducement claims. And that's, if we look at the Ford case, it addressed fraudulent inducement, Lanham Act claims, and tortious interference claims. And in each of those instances, it found that they did not relate to the underlying agreement and did not require the agreement. And in that way, they stood alone and were not arbitrable. And I will point out in that case that was a broad that did involve a broad arbitration provision that covered any claims arising from or related to the agreement, which is not what we have here. We have a narrow provision that only covers claims that arise from the agreement. And so, with regard to Lanham Act, fraudulent inducement, tortious interference, they simply just don't arise from the agreement. They stand alone under Ford.
Why is it that your client decided not to do arbitration?
Polyflow has asserted in this case a number of claims that it previously released in the earlier case. And we've provided a comparison of those claims, and you'll see that they are, most of them are largely identical. And in fact, in the first amended complaint, Polyflow makes clear that it's relying on activity that occurred before the settlement agreement, and that's at record 1203 and 1204. Where it specifically sets out before the settlement agreement, and then provides a kind of laundry list of bad acts that it claims SRTP is guilty of. Further, in the counts themselves, it refers to activity involving Exxon, Petronas. Both of those companies were part of the 2015 lawsuit. And so we don't want a case, and we think they should they should be resolved in federal court, not in front of an arbitrator. They simply do not arise out of this agreement. I mean, if we look at what the parties agreed to arbitrate, and that's really the focus here, what did the parties agree to arbitrate? It's very clear. They agreed to arbitrate only those disputes that arise out of the agreement.
And that's it. The word is action.
The word is action, and in this case, we contend that action means a claim or a cause of action. And we have addressed the Archer case in our response to Polyflow's supplemental authority, and that's further underscored by the party's definition of a claim in this case, where it defines claim synonymous with action, where the parties wanted to refer to an entire litigation. They did so. For instance, they referred to the 2015 litigation, or they refer to it as a civil action. In this case, action should be construed to mean cause of action, and that's further underscored by the fact that to read action as the entire action in C4 would then render any claims that arise under B1 and are required to be arbitrated, perhaps at some point under Section B5, it would render that a nullity, and that shouldn't be the result here. Going back to two issues, with regard to the release claims, I understood Polyflow to argue that is an issue for the arbitrator. It's simply not. In this case, those claims, the released claims that are now included in Polyflow's current complaint were released in the same agreement that the arbitration clauses are found. And so that is not, those claims are not something that the parties agreed to mediate. It perhaps could be a different result if the release claims were in a different agreement or something along those lines. But here they were released in the very same agreement. So it makes no sense that the parties would have agreed to release those claims, but still agreed to arbitrate them at some point in the future. With regard to the failure to mediate, the framework in Section B is very clear that if Polyflow believes that SRTP is in violation, it can raise that issue with the neutral pipe expert, and then he will go forward with his analysis and mediation if necessary to resolve the dispute. SRTP has complied with every request from the pipe expert with regard to providing products. So for examination, products and information. So to the extent that Polyflow claims that there are products that it believes are in violation, but SRTP has not turned over, that is the result of Polyflow not raising that issue with the neutral pipe expert in the first instance. And I see I am out of time.
Yes, sir, you're out of time. We'll go back to Ms. Stratton for rebuttal.
Thank you, Your Honor. I'd like to begin with the issue of mediation. You've heard opposing counsel describe their view of why mediation was a prerequisite here, and we obviously vehemently dispute that. And that's precisely why the issue is not clearly established such that this court could decide it, because no rational mind could do anything but agree with Mr. Schlather's position. He's not articulated why it is clearly established and essentially undisputed here that a procedural prerequisite was breached. So all of his arguments about what should have been done in the mediation process, that's all for the arbitrator to decide under this court's procedural arbitrability precedents. I'd like to also briefly discuss the issue of release. Appellees appear to be trying to take the issue of release and frame it as a question of what the parties agreed to arbitrate, a question of substantive arbitrability. But this court has made clear that it does not consider the merits in its substantive arbitrability determination. You said that in Chevron Chemical, you said it in Bank One v. Hill, and in numerous other cases. And what Mr. Schlather's argument does by asserting release as a question of the scope of the arbitration agreement is inject the merits into the substantive arbitrability determination. For this court to decide whether Polyflow released or sued on released claims, it would have to resolve the merit. That is a basis for Polyflow's counterclaim in this case. That's not properly before the court in a substantive arbitrability analysis. Release is a defense. That's how this court should treat it. And that's exactly how Mr. Schlather's answer on behalf of Specialty RTP in the district court treated it as an affirmative defense on the merits, a basis for their merits counterclaim, and therefore it's properly submitted to the arbitrator as part of the underlying merits of the dispute. Now, I'd like to move on to addressing the interaction between C4 and B5. There is a way to harmonize these provisions, to read them quite naturally in a way that doesn't treat them as two separate arbitration provisions or treat them as a limitation on one another. First, there is nothing in the text of either C4 or B5C that suggests that they apply to anything other than the entirety of the agreement. There is no limiting language, as Judge Jones noted. And the most natural reading we submit of B5 is that it is inserted to protect the breadth of the parties' arbitration agreement, because it appears in a section laying out certain procedures for resolving certain types of disputes under the agreement. And it heads off the potential argument that by laying out those procedures, these were the only substantive claims the parties intended to arbitrate. And so the text of B5 says very clearly, for purposes of clarity, we are clarifying that we are agreeing that any dispute arising out of or related to this agreement shall be arbitrated. And so in C4, you have an extraordinarily broad arbitration provision. In B5C, you have another extraordinarily broad arbitration provision, and broad plus broad equals broad. It does not, as Mr. Schlather contends, equal narrow, and it does not equal arising under, which is what he said at the beginning of the argument, that we agreed in C4 to arbitrate arising under. This court made clear in Explo that arising out of and arising under are not the same, and that arising out of is a broader arbitration clause than the more narrow arising under. It's Mr. Schlather's burden to furnish this court with positive assurance that this arbitration agreement cannot be read to cover this action. And in order to meet that burden, appellees have had to rewrite the arbitration language to arising under and call arbitration clauses that this court and others have repeatedly called broad narrow, insisting upon that. And our opinion, Your Honors, is that that doesn't amount to positive assurance that these claims are not arbitrable. I'd also like to briefly distinguish Ford, which Mr. Schlather relies upon. In Ford, the court made it clear that when a tort claim is based upon a breach of contract, it's arbitrable. There was no breach of contract claim in the case. The parties could have completely complied with their obligations under the contract, and the tort claim in that case would still have proceeded. That's why the Ford court was able to say, this contract is legally irrelevant to this tort claim. We can treat it like it doesn't exist. That's not possible here. For example, Mr. Schlather asserts that the Lanham Act claims have nothing to do with the settlement agreement, but I'd refer the court to paragraphs 96 and 114 of our unfair competition claims, which are based specifically upon appellees' misrepresentations about the terms and scope of the settlement agreement itself. The fact finder simply could not resolve those claims without consulting the terms and scope of the settlement agreement, and they arise out of the contract. Thank you.
All right, thank you very much. That concludes our brief hearing for today, and we'll take the case under advisement.
Thank you.